We are now just a couple of weeks removed from the guilty verdicts against former Minneapolis cop Derek Chauvin in the death of George Floyd. And now comes word his defense attorney is calling for a new trial, alleging new evidence pre-trial publicity may have affected a juror, and that may have affected Chauvin's right to a fair trial. Here to discuss the next steps for the legal case, Georgetown Law School lecturer Frederick Lawrence. Mr. Lawrence, great to have you with us. We appreciate your expertise this afternoon. All this has to do with one of the jurors and a picture that has resurfaced online of him wearing a T-shirt at a rally here in Washington a number of weeks ago that has sort of called into question his ability to have been fair and impartial, and perhaps even the possibility that he misrepresented himself to the judge in the voir dire, where you're questioned ahead of the jury selection process. Talk a little bit about that, and then what's your view here? Is this something that rises to the level of throwing out a verdict that was reached by a jury of his peers? What do you think?
First thing to note is that this idea of a motion for a new trial is not unusual. In fact, it's standard procedure for defense to do that. What we're going to see right now is a preview of what the ultimate appeal will be. I'm assuming that the motion for the new trial will not be granted and will go up on appeal. Is there something to an argument that a juror might have misrepresented in the voir dire where he's questioned? There could be something to that. The fact is, I believe that the juror is going to say something along the lines of, I said I'd never been at a post-George Floyd anti-police rally. I didn't think of a Black Lives Matter rally as being in that context. Yeah. You agree with them or disagree with them, that's plausible. Real question now is going to be, would it have changed the verdict? Would it have affected the verdict? I think the fact that the evidence was so overwhelming, that the jury came back quite so quickly, makes it a steep hill for the defense to climb on this.
And you do make the case here that this happens all the time. When you don't like the verdict, the first thing you try to do is discredit it wherever you possibly can. That's just sort of a defense attorney doing his or her job. But it also does sort of raise the possibility that this case immediately gets appealed, and then another judge or a number of judges will take a look at this thing and reconsider the facts around this case. In any result, the overturning of a jury's verdict is a very rare occurrence, isn't it?
It is a rare occurrence. And one of the important things, Dave, to remember is that whereas up until the conviction, all the presumptions go in favor of the defendant. Presumption of innocence, we assume that somebody is innocent until proven guilty. All of that all shifts once you get to a conviction. So now we presume that the verdict was a legitimate, rational one, unless the defense can prove that it wasn't. So it happens, but it's pretty unusual. You'd have to show that there was an error in the trial. Doesn't appear to be an obvious one to that. You'd have to show that there wasn't sufficient evidence that would allow a rational jury, a reasonable jury, to reach their conclusion. There certainly appears to have been enough evidence. My goodness, just the tape itself was enough to support the jury verdict, and they put in a lot more than that. So yes, there'll be an appeal. Yes, there'll be arguments. But my sense now, as it was during the trial, is that the prosecution's done a good job, a strong job. I don't see the defense being able to overcome this verdict.
And this is kind of a technical question, but I think it's important to all of this. If it goes to that appellate court, do they only consider then the evidence that's raised in the trial and what the court knows about this one particular juror? It's not as if that juror gets called back and has to testify at the appeal, is it?
That's correct. That will not happen in an appeal. No new evidence happens at an appeal. What the appellate court might do is say, this raises enough concern for us that we remand the case back to the trial court to do a hearing to decide whether it would have affected the outcome. That, too, is pretty rare. But the appellate court itself is bound by the record below. They don't take any new evidence.
And the other thing, I suppose, that, and this is difficult to know, so I'm asking for an educated guess here, I suppose, on a timeline here. Does this get expedited at all? This is a fairly routine thing. You appeal the court's verdict. When should we expect new developments in this, in your view?
I think the motion for the new trial you'll hear about relatively soon. There'll be briefing on both sides of that, and the prosecution will respond to the defense motion, and then the judge will make a decision. As I said on that, I'd be very surprised if the trial judge agrees to a new trial.
Yeah.
Then they'll bring an appeal. I don't know exactly what the backlog looks like in the Minnesota courts, but typically I would think anywhere from 6 months on till you finally get a final decision.
And that's another important aspect of this, too. This is all done under Minnesota statute because it was in a state court. It would stay in the state court system,
right,
presumably.
But remember, this is why a lot of people focused on this. He was remanded to the custody of the public safety. He was put in jail immediately upon conviction. So he's not out pending appeal.
Yeah.
So the prosecution's not in a rush. The defense is in a rush. But I don't think in a murder conviction that anybody's going to be let out of jail pending appeal. That is almost never the case.
Georgetown Law School's Frederick Lawrence with some very important perspective on what was, I think, for a lot of people, something of a surprising development. Perhaps we shouldn't have been surprised at what happened, but the grounds for it are ones that have raised a lot of concern. Frederick Lawrence, thank you so much for your time this afternoon. It's been really helpful. Many thanks.